that, you have Islamic law legal system operating again in Nigeria for Muslims that believe in Islam, right? So, next slide, please.
Wait.
Okay, so like I said, the legal system in Nigeria has a lot of other legal systems operating on the English common law, Islamic legal system, you have customary law legal system, and the rest. So because of that, you have a system of courts again, operating all these types of courts that administer justice in line with customary law. Then at the same time, you have English court system. You have the state high court, you have federal high court, as we shall see later, and we also have magistrate court. Most important thing to note is that the legal system in Nigeria is based on a judge sitting alone to decide cases. So we don't have the jury system. You understand? So a judge sits alone, he alone, especially at the lower level, and he listens to both parties in the case. So you don't have to call juries to come and support the case being entertained by a judge, right? So that is why I said the trial system is just based and it's not jury based. It just sits alone, especially at the lower level, or if it is at appeal stage, you might have 2 or 3 judges who hear cases, evaluate evidences, and come up with judgments. Next slide.
Wait.
Okay. So now, let us look at the English common law legal system. That is the first legal system that we need to analyze. This system of law is imposed on Nigeria by the British colonialists. So how did it happen? It happened in the year 1861 when the British formally came to a place called Lagos. So Lagos is along the coastal part of Nigeria. So they came through their ships and boats. When they came, they discovered that there are communities within Lagos, mostly the Yoruba community. So they now executed an agreement with the then king of Lagos. That king is called King Dosum or Dosemu in English. So what's the nature of that particular agreement? In that agreement, the king now formally invited the British to come and take over Lagos and administer it the way they like, through a treaty that is called Treaty of Succession. But don't forget that before that time there was war between King Dosomu and the British. So they now overpowered him and they now executed that treaty. So it was from there that the English people came into Nigeria formally. Oh, we understand. So what they did was to now bring English law, because the British are from England, right? They are the English people. So majority of them came from England, not from Scotland, Northern Ireland, or Wales. So they decided now to import that English law to Nigeria. So that English law, for us Nigerians, we call it received English law. Meaning, Nigerians now receive that law from the English people. So there are a lot of argument as to whether we receive it or it was imposed on us by force. But a lot of scholars said the law was forced on Nigerians. The English decided to introduce it without the consent of Nigerians. So they did that through laws. The first law was Ordinance number 3 of 1863. This particular ordinance said the same English law is now applicable in the whole territory of Lagos. So they later established a court. They call it Supreme Court. So they enacted a law mandating the Supreme Court to entertain matters relating to English law. And currently, we have a law in Nigeria which we call Interpretation Act. Section 45 of that act now said English law must apply in Nigeria. Oh, understand? So, now the question is the received English law, what does it consist of? We'll see later on the next slide. Next slide, please. The received English law consists of 3 laws. So, 1, common law. 2, equity. Number 3, statutes of general application. So, English law in Nigeria consists of 3 other laws. 1, English common law. 2, principles of equity. 3, statute of general application. So what do they mean? English law is consistent of common law. So when we say common law, it means the law that is common to the people of England. So this is the law that came from the customs of the English people. You know, naturally laws usually come from a custom. Practices are usually of a particular community. So the English people have their own way of doing things in commercial activities, in the buying and selling of land, in marriages, in family matters, which they have been observing for many, many, many years. So it is this law which is common to the people of England that is called common law. And it was developed naturally by the common law judges because the then King of England has courts that administer justice. The King's Bench, Court of Common Pleas, and Court of the Exchequer. These were the 3 dominant courts. They were populated by common law judges, which historically during that time were clergy knowledgeable in English law. So they developed the law with time and they developed precedents. So that is part of received English law, common law, which is now applicable in Nigeria. The next law is equity. By the nature of common law, because it came from the custom of the people of England, it has some technicalities. It is rigid, it is complex, because it was designed in accordance with their custom. It is not flexible. So because of that reason, many English people now complain to the English king that this our law is very hard, this our law is very difficult, and it is not changeable. Anytime we go to the court doesn't give us right or remedy unless it is in accordance with common law. So the King of England then decided to commission the Chancellor. So the Chancellor was an advisor to the King of England, and he said, come up with remedies that will benefit my people. So the Chancellor now established what is called the Court of Equity. So equity simply means fairness. However, technically when we say equity, it means those laws and principles that were created by the Court of Equity. And the Court of Equity was manned by the Chancellor. The next slide, please. So the reason why they created the Court of Equity was for it to solve some of the technical problems created by the common law. Next slide.
Yeah. Come on.
It's not moving?
The signal. I'm sorry.
Okay. So I wanted for you to see the slide that's discussed equity and what it means. But you see, the Board of Equity developed some maxims. And these maxims were used as a basis to give remedy to English litigants that could not get remedy in court of common law. So some said these maxims are 15 in numbers, some said they are 12, right? So looking at the history, we said law of equity was developed by the Court of Equity through the efforts of the Chancellor, who was then a religious leader and advisor to the King of England. So, the laws of equity were created to solve the problems of common law, rigidity and complexity of the common law. So, the Chancellor was given permission by the King to come up with solutions to solve some of the legal problems of common law. So, that's equity for you. So, the next part of English law is Statute of General Application. When we say Statute of General Application, we mean those laws and legislations that were enacted by English Parliament and they were now transported to colonies. They apply as part and parcel of the laws of the colonies that were then under Britain. But however, the laws called Statute of General Application stops by the year 1900, meaning after 1900, no more Statute of General Application is now taken to colonies. What is the reason for taking statutes made in England to colonies? They said the reason was because most colonies were under colonization. They were not sophisticated. They couldn't be able to legislate on their own. So they decided to import these legislations from England to most of the colonies. In the case of Nigeria, these statutes of general application are still applicable up to this moment. Some of them were made in the year 1600, some in the year 1800. You understand? But still they apply because they are part of our English common law legal system. For instance, we have the Infant Relief Act, which is a law that regulates contracts by infants, contracts by young persons. We have the Conveyancing Act, which regulates land transaction. It's an old English law. This particular law, Conveyancing Act, was made in 1881. It's applied in Nigeria up to this moment. Then we have the Wills Act, which regulates how people should live will under English law. Then we have the Statute of Fraud, which was equally enacted by the English Parliament in the year 1600. So next slide. So these are the components of the same English law. Common law, equity, and statute of general application. They still apply in Nigeria. Are we together? So now, the English legal system has body of laws. And this body of laws operates up to this moment in Nigeria. So we have criminal law, English criminal law. It applies in Nigeria up to this moment. We have law of torts. It applies in Nigeria. We have law of property. We have law of contract, commercial law, English family law, criminal law and procedural, company law, international law. All these laws are English laws. Even though they were modified by legislations made by Nigerians, but the principles are still what? Based on English law. So that's the body of English common law in Nigeria. So the next slide, please. So, apart from English common law
Tadi cepet tadi.
legal
Yang
system,
baru cepet tadi.
there are laws that support the English common law legal system, but there are laws made by Nigeria. There are laws made by Nigeria, but they support the English legal system. Example of that law is the Constitution of Nigeria. Nigeria has a constitution which is the sovereign law. That law was made in 1999. This law is based on the English legal system. Principles relating to government, principles relating to institutions of government, principles relating to rights of citizens, principles relating to political, economic, and social matters. All are contained in our constitution and they support the English legal system. Currently, the Nigerian constitution, like I said, is the supreme law of Nigeria. Any law that conflicts with the constitution, then it is void. It will not be applied by virtue of the fact that it is inconsistent with the Nigerian constitution. This constitution again laid down the system of government in Nigeria. So that is why in Nigeria we have the presidential system of government. We have the executive part of government, we have the legislative part, and we have judiciary. All are contained in the constitution of Nigeria, and it is in line with the English legal system. Next slide, please. Okay, so apart from constitution of Nigeria, we have legislations, laws enacted by the National Assembly, which is the highest decision-making body when it comes to laws in Nigeria, and the State House of Assembly. Nigeria has what is called the federal system of government. That means there is a federation which is governed by the president of Nigeria. Then we have states. The states now are somehow independent because they have their own governor, they have their own house of legislators, and they have their own courts. So all of these bodies, the House of Assembly of States, the National Assembly, they used to enact laws. So when they enact these laws, they regulate a lot of activities in Nigeria. And all of these laws are in line with the English legal system, even though they are made by Nigerians and Nigerian legislators. Next slide, please. So, that is English legal system for you. The next legal system is called the customary law legal system in Nigeria. So, this is a system that is based on the customs of the people of Nigeria. Like I told you from the beginning, Nigeria has more than 200 ethnic groups. Each of the ethnic group have their own law based on their own custom, right? Like for instance now, I'm a Nigerian, my custom is Fulani. You understand? I don't know. He's Hausa. So, in a way, linguistically we are different. Hope you understand? So I have my own custom with the Fulani. He has his own custom with the Hausa. Then we have Yorubas. The Yorubas too, they have their own custom. So these customs now regulate our life as part of our customary law. So that is why we have legal system based on customary law. So now the question is, what is a custom according to Nigerian law? A custom is a rule which is found in a particular district or community in Nigeria, which has been used for a long period of time. It consists of our traditions, usages, history, and practices. So it has to do with the way we dress, the type of food that we eat, how we marry, right? How we bear children. If there is dispute, how do we resolve that kind of dispute? Our customs regulate that aspect of our life. So it is from custom that you have customary law. Your custom with time it metamorphoses and becomes customary law. So customary law now comes from custom. It becomes an obligation for all members to comply with that custom. If you don't comply with that custom, then you are breaching customary law, and there will be sanctioned by the community. Next slide. So now, in Nigeria, despite the fact that we have customary law and we have a legal system that operates according to custom, customary law does not apply directly. It is applied subject to restrictions, subject to some certain conditions. So it's unlike English common law, which apply directly against the people, whether they like it or not. In the case of customary law, it is applied subject to certain restrictions. And these restrictions were imposed by English law. So what are these restrictions? Number one, if you want to apply any customary law in Nigeria, you must prove it. You must establish by evidence that it exists in your community. Number two, you must convince the court that that particular custom has not been abrogated or abolished. Why? Because the nature of custom it changes with time. And people used to migrate from one area to the other. So there is a possibility that that custom that they had 10 years ago is no longer applicable. So now you have to establish it that it exists and it has not been abolished. Then lastly, you must show that that custom is a valid custom. So what do you mean by valid custom? The next slide will explain to us. Next slide. When we say a custom must be valid, it means that it must satisfy three tests. So there is a rule which a custom must satisfy before it is applied. So this is based on three principles. One is called repugnancy principle. The repugnancy principle. Number two, incompatibility principle. Number three, public policy principle. So what do they mean? And this is very important, especially for countries that share similar experiences that have customary law. So, number one, a custom must not be repugnant. If it is repugnant, it will not be applied or enforced by the court. What we mean by repugnancy is that that custom must be in line with the principles of modern society. So what are these principles? One, it must be fair. It must be just. If any custom is unfair, if custom is unjust, then it will not be recognized by the court. Second thing is a custom should not be barbaric. So what do they mean by a custom being barbaric? Any custom that doesn't make sense, the court will not apply it. So for instance, part of the custom of the people people of some part of Nigeria is when they have twins, they kill all of them. So if somebody has twins, they kill the twins. Why? Because according to their custom, twins are evil. Any person that wants twins, those twins are evil, they will come to kill him. So that is one of their custom, right? So they kill the children. Number two, we have a community whereby a woman can marry a woman. You understand? Just similar to gay rights in modern times, right? But before gay rights, now, some communities in Nigeria, they have a custom. So how does it work? If a woman is old, she has never had children, she can decide to go and marry a young lady. She will bring the lady to her house. The lady will help her to cook, will help her with other work activities in the house. Although there won't be sex, you understand? There is not any sexual relationship. So, but it's like when she died, that wife, her wife, will inherit her. You understand? So when the British came at that time, they said this custom is very bad. This custom is offensive because a woman should not marry a woman. Then, hope you understand. So these are part of the rule related to repugnancy. Meaning, a custom should not be repugnant to natural justice, equity, and good conscience. So, number two, incompatibility rule. Any custom that is to be applied in Nigeria must not conflict with the provisions of English law. So if English law has a principle related to any particular activity, then a custom should not come on conflict with that principle. So example, if English law regulates land, that land belongs to the sovereign, and you have a customary law now that says land does not belong to the sovereign, it belongs to the individual. So in this case, they will say that customary law is incompatible because it conflicts with English law principle. Another example of incompatibility is under English law, you can make a will disposing of your property to whoever you so like. However, under customary law, we don't have the right to do so. Because under customary law, you cannot dispose of your property the way you like. You must give your property to your children. Are we together? So in this respect, English law, English judges at that time said this principle under customary law is incompatible with English provisions. Then the last one is public policy. Every customary law must not go against public interest of the society. So a custom should not be immoral. Any custom, even though to the people it is good, but to the English it is not good, it is immoral, then you cannot apply it. You understand? So that was why I gave you these cases to explain all of these principles. So let me just go through the cases so that you understand. In this case, it's called Guri versus Hadija Native Authority. It has to do with a singer who sang a song and he abused the king of his community. So the king now ordered for his arrest. He was arrested, he was tortured, and he was put in prison by the king. So he decided to sue the king in a court of law, English court. So when the matter was taken to that court, the court said, okay, who was the accuser? It was the king. Who was the police? It was the king. Who was the prisoner? It was Goody. Right? So they said it goes against the principle of fair hearing. Because the king has now entered into the shoe of the accuser and the prosecutor. So he is now a judge in his own case. He is judging a case that affects him. In that case, it is that particular custom that allows the king to arrest his subject is repugnant to natural justice. Another example is in the case of Ephraim versus Okon Atta. If someone is a slave according to a custom, even if he died, then he will continue to be a slave. That is part of their custom. He is dead, right? Once somebody is there, where do you take him? You take him to the graveyard, right? According to their custom, if he is your slave, you will now say, no, they should bring him to your house. So he will be lying in your house, serving you, even though he is dead. Reason being because he was already a slave before he died. So this custom doesn't make sense, right? So that was why the court now said that custom is repugnant to natural justice. So the example I gave you of a woman marrying a woman was in this case, Mary versus Egu, whereby a woman married another woman. And when they asked her, why did you marry another woman? She said, because our customs allow it. And the court said, no, this is a bad custom. Because the only known marriage is between a man and a woman. Hope you understand? So these are the principles which a custom must satisfy before it becomes a law. Next slide. So now, we've discussed English common law legal system, right? Customary law legal system. So the next legal system is Islamic law legal system. So this legal system is for Muslims in Nigeria, especially in the northern part of the country. Muslims that live in the northern part of the country operate the Islamic law legal system. And we all know, especially for Muslims, that Islamic law regulates the life and activities of Muslims, right? And Islamic law comes from some primary and secondary sources of law. Primary sources of law are what? The Quran, the holy book of Muslims. Then the Hadith, right? The practices, the sayings, and the tacit silence or approval of the Prophet of Islam. Peace be upon him, right? So, the secondary sources has to do with ijma, consensus opinion of Islamic jurists, then analogical deductions, which is called qiyas, right? So, the totality of these sources of law regulate Muslims' life, whether in civil matters or in criminal matters. So if someone wants to enter into a contract, for instance, he's a Muslim, there are rules which he must follow. One is that he must engage in lawful transaction, right? So a Muslim is not allowed to go and engage in unlawful transactions. For instance, the buying and selling of alcohol is prohibited in Islam. Or the buying and selling of pigs, right, is equally prohibited. So that means Islamic law regulates the life and activities of Muslims of Nigeria in line with the principles of Islamic law. Just like Islamic law does not allow gambling, right? So likewise, when someone commits a criminal offense under Islamic law, you stole another person's property, or you commit murder, homicide, you'll be arrested and be taken to Islamic courts. So, the Islamic legal system now operates in Nigeria based on the principles of secondary and primary sources of law. Next slide.
Come on. I'm sorry. Court system.
So, after Islamic law, you need to understand that we have a court system. The types of courts and the way they are designed to operate in Nigeria. So in Nigeria, we have English courts that administer English law in line with what? English legal system. We have customary courts that apply customary law in line with customary law legal system. And we have Islamic courts that apply Islamic law. So the English courts are now stated here. So we have the Supreme Court of Nigeria, it's an English court, right? We have the Court of Appeal, Federal High Court, the National Industrial Court, the State High Court, the Magistrate Court, the Election Petition Tribunals, and the Tax Tribunal. All of these courts have their own jurisdiction, meaning the cases that they are to entertain. So they are modeled in line with English law. And that is why we call them English courts. The next slide. Then, apart from English courts, we have Islamic and customary law courts. So, before we go to Islamic and customary law courts, you want to understand that the English court system operates a dual system. That means these courts have civil jurisdiction and criminal jurisdiction. Meaning, if the matters are criminal in nature, you can listen to them. If they are civil, you can also listen to them. And they are modeled in line with what is called the English binding precedent. English binding precedent. What does that mean? It means that when courts pass decisions, those decisions are binding on the courts and they are binding on other people. So that is why it is called binding precedent. And like I said, the courts have jurisdiction, both criminal and civil, relating to law of tort, relating to contract, relating to criminal law, relating to human rights law. So next slide. So the customary courts that administer customary law, this is how they are designed. One, we have the customary court of appeal of a state. Then we have the customary court or district courts. So there are courts that are within villages. So these are called customary court or district courts. Then there are courts that are within cities, and they listen to appeals from the district courts. And that is why they are called customary court of appeal. So in most cases, these courts only entertain civil matters. They don't entertain criminal matters. So if it is a criminal matter, it goes to the magistrate court. English court, it does not come to the customary court. Next slide. Then we have the Islamic courts. The Islamic courts are designed according to this order: the Sharia court of appeal of a state, the area court, the upper Sharia court, the Sharia court. This court administer only matters relating to Islamic law. And unlike customary courts, this court administers both criminal and civil jurisdiction. So they entertain criminal matters and they also entertain civil matters. And like I said, they are only available in northern states, where I come from, where you have majority of Muslims. In the southern part of Nigeria, you hardly see the Sharia courts. Next slide.
Sorry.
Okay. So now, since we now know the legal system in Nigeria, right? We have the English common law legal system. We have the customary law legal system. We have the Islamic law legal system. The next system is the system of legal profession. Because if you have a legal system, you need lawyers, you need judges, personnel that will administer that legal system, right? So the way it is designed in Nigeria is we have one legal profession. So that means if you want to become a lawyer or a judge, the first thing is you must go to the university, to a university in Nigeria or university outside of the country. And you have to obtain Bachelor of Laws, LLB degree. In most cases in Nigeria, LLB degree is 4 years or 5 years. I don't know how many years is here in Indonesia. For us, it's 4 or 5 years. So you have to study for 4 or 5 years. Then, if you didn't obtain your Bachelor of Laws from Nigeria, from outside of the country, then there are rules that apply to you. So, for instance, if you finish your LLB now, right? How many years is here? 4 years. And he wants to go back to Nigeria to become a lawyer. So he has to do what is called conversion. So what is that conversion? He will go to the Nigerian law school. So he will study for 1 year, a year. You understand? And that is what we call Bar Part 2 program. He will study because they will teach him the practical aspect of Nigerian law. And there are some courses that are peculiar to Nigeria which he has not studied. So he will now undergo those courses. Hope you understand. Then, lastly, if you obtain your LLB degree, you go to law school for 1 year or 9 months. Then you sit for an exam. If you pass the exam, then you now become a lawyer. You understand? In Nigeria, officially, we don't call them lawyers. We call them legal practitioners. Hope you understand? We call them legal practitioners. So if you become a legal practitioner in Nigeria, you have the right to practice in dual aspects. You have the right to practice as a solicitor. Unlike in England now, if you qualify as a lawyer in England, you either practice as a solicitor alone or a barrister. The solicitor is the person that knows all the legal documentation. He doesn't appear in court to defend cases. Whereas a barrister is the person that appears and represent clients in court. Right? We call him advocate. In the case of Nigeria, you qualify in two respects. You are a solicitor, you draft legal documents, an agreement for clients. At the same time, you now go to court. You wear a lawyer's suit, you go to court and you present them. Right? Next slide, please. So that is how our legal profession is designed based on our own legal system.
I'm sorry for the signal, but
Right.
Come on.
So I don't know how it operates here in Indonesia. You become a solicitor or a barrister. How does it work? Dr. Dani?
Usually, after they graduate, students have to take, if they want to take as a lawyer, so they have to take special course for like 3 months, and then there will be a national test organized by the lawyer profession association, and then after that, they will provide a certificate, but they have to take not an internship for 2 years, be dedicated and selected
Panjang ya
law
jalannya ya.
and
Kalau
also
jadi
for
belajar
4
ya.
hours, and then after that, they can be, they can enroll as a lawyer, or if they want to be a
Waalaikumsalam.
usually there will
Lagi
be a
di stage
national
show,
selection,
guest lecture.
they will become the civil servant
Gimana?
of the government, and then they will go to, usually they will have to take the training for 1 year to 2 years, and then they will be taken and enrolled as
Warna?
a public attorney.
That's a long process.
That's what.
But for us, you just go to the
Hari ini nggak ada.
university, you finish your degree, you go to law school 1 year or that.
Oke.
If you pass the exam,
Oke.
you become the solicitor.
Ya.
You feel that? So
Misalnya.
now, having listened to all of this, the Nigerian legal system and legal profession, what are the challenges that we have in Nigeria when it comes to our own legal system? Number one, we have multiple legal systems. Why? Because we have English common law legal system, customary law legal system, Islamic law legal system, all operating at the same time. So it can be confusing. Don't you understand? So, like I said, if you become a lawyer in Nigeria, they will give you a license. You are an advocate, you are a solicitor. The law says you can appear in any court in Nigeria. So that means you can go to Islamic law court, you can go to customary law court, and you can go to English courts. But the problem is you can't know everything. You understand? So you will see somebody, for instance, me, I'm a Muslim. I know a little bit about Islamic law. So people used to ask for my services and I go to Islamic law courts. But I don't know customary law. You understand? So, but the law says I have the right to appear in customary court. So that means I can go there and confuse the court. Or the court confuse me. Right? Because I don't know anything about customary law. Why? Because of the problem of multiple legal system. Then number two, this different court system creates technicality. Because you know courts have procedures. If you want to start a case, there is a procedure that you have to follow. They will tell you that you have to come by way of motion, whether motion ex parte, right? Or motion on notice. All these are technicalities, which at times creates confusion because of the multiple legal system. Then number three, the English legal system is conservative in nature. It is not flexible like Islamic law. And because of that, you tend to see problems here and there because it doesn't accept change. Right? For instance, now, as a lawyer in Nigeria, if I'm to appear before an English court, I have to run. There is a way I have to dress. And this has been the system for many years. You understand? So if you don't do that, then the court will not give you audience. So this has to do with the common law legal systems and the problems that we have. All because of what? Colonization. Next slide. So these are some of the problems we identified with the Nigerian legal system and legal profession. So that is the end of my presentation. I don't know if later you have questions for me. Thank you very much.
All right, so the next session it will be question and answer and also discussion. We provide the first term. I need two students to deliver their question and answer based on the explanation that already delivered by our professor. And please raise your hand and introduce your name, then deliver your answer. Okay, first one, the second one, maybe from girl, maybe anyone? Okay, so you go for the first question first.
Someone is raising his hand there.
Oh, okay, the second one. Yeah.
Thank you so much for your time, Professor, and for your knowledge giving us about the Nigerian legal system. I just want to ask, since Indonesia will replace the old Dutch law system to the Indonesian law system, we made it our own. Do you think that the Nigerian legal system will change the common law system to like making their own legal system and will replace the common law system as like one of the five major Nigerian legal system? Thank you.
Maybe we directly answer first. Okay.
Thank you very much for that question. You see, they have tried several to change English common law legal system, but it has been difficult. And there is reason for that. Nigeria is a complex environment. We have many ethnic groups. So if you change the English common law legal system, then you have a problem of how do you administer justice that is uniform. Because each state has a lot of multi-ethnic nationalities. So the leaders of Nigeria decided to allow English common law legal system because it unifies the country. Because English is the language of Nigeria. Everybody is supposed to learn English. English course speaks in English. You have to speak in English if you go to English course. So their own idea is if we replace English legal system, then how do we have a unified country with one legal system? Because anywhere you go, they have their own legal system, either Islamic or customary. So that is the reason why they decided to leave it, because of the need for uniformity in the country. Thank you.
Right. Go to the second question, please.
Yeah, so I'm from Australia, and there's a lot of overlap between the Australian and Nigerian system, obviously because of British colonisation. But I find it curious that in Nigeria there is no jury. Has that always been the case in Nigeria? And do you support that, or do you prefer the jury-based system?
Thank you very much. That is a good question. So the reason why we had one judge based system in which only a judge will now sit and decide cases has to do with colonization itself. So when the British came, they established the English legal system. So their own belief was that the people were not sophisticated enough to be Jews. So they decided, okay, since the English judge is the most educated, he knows the law, he should be the one that will judge the case. So because of that reason, that was why they didn't advance a system of jury. Secondly, I don't support the jury system. Why? Because the jury system, like we see, especially when we analyze the US system, the UK system, is prone to a lot of problems. You understand? You see how independence of the jury is somehow eroded. You understand? You see interference and the rest. So, Nigeria being a complex country, if we adopt the jury system, the level of education and awareness among the people is not high. So there is a tendency that the jury might be corrupted, especially when it comes to sensitive cases. You understand? So this, in a way, interfere with the judicial administration of justice. So in that respect, I think it is better we continue with one judge. Why? Because he's educated in the law. He knows the evidences. He knows the rules related to admission of evidence. You understand? So based on legal technicality, you get the point. He can be able to arrive at a decision. And we have an appeal system in the sense that if a lower court or a lower judge decides a case erroneously, it can go on appeal. And the higher you go, the more sophisticated you have of judges that can sit down and analyze the case. So if the lower court judge made mistakes, there is a possibility that those mistakes can be corrected at the higher level. So based on the nature of our country, based on our own situations, I think we should not adopt the jury system. Thank you very much.
Okay, thank you. We open the second term for 2 questions. So anyone wants to give the question, please raise your hand and introduce yourself. Or maybe we will point at someone. If there is no one, we'll ask. Yeah? Okay? Who wants to ask? Okay, yeah.
Thank you for the opportunity. I would like to ask about the types of law in types of legal system in Nigeria, because in Indonesia, the common law system, Islamic law system, and customary law system are working at the same level, so it does not interfere with each other, like it complements each other, work in harmony. So does in Nigeria, does it have a hierarchy, like where what law above other, or is it the same and make some harmony to decide a decision of?
Yes, that's a good one too. So his question is whether we have hierarchy of law in between all of these laws that I mentioned: Islamic law, customary law, English law. The way it is designed, English law has hierarchy. Do you understand? So there are a lot of cases that came before the court that conflict with each other. So you might have a Muslim who has entered into a transaction under English law and at the same time under customary law. So 3 laws now will apply to him. So the question is, how do you resolve that? You only resolve that by looking at the rules relating to conflict of laws. We call it conflict of laws. And in that respect, English law is always higher. You understand? Above all other laws. Although there are a lot of judicial interpretation as to whether those laws too are independent of English law, they can stand alone on their own, but that is not the case. English law is always higher. For instance, you can see a Muslim now in Nigeria writing a will, giving out all his properties to his girlfriend. Under Islamic law, you cannot do so. You can only give 1/3 of your property to someone. If you have children, you must leave the rest for them to inherit. Another example is you will see a Muslim marrying a non-Muslim under English law. So at the end of it, there will be conflict. Because if he dies, what happens to the property that he left behind? Because under English law, she is going to inherit all if he doesn't have a will. Whereas under Islamic law, you can only give her percentage of that property. You have to leave the rest for his parents, his father, or mother. So in this case, you have conflict of law. But the way the Nigerian courts have interpreted it is English law is always higher. Thank you.
Okay, thank you for the questions. Okay, we go to the second question of the second term. Anyone wants to ask the question? For girls, maybe? Okay, face up.
I'm Faisal from Kenya. I just wanted to ask if, say, inshallah, I want to be a legal practitioner in Nigeria. In Kenya, we also have similar procedure and everything for the common law. So I wanted to ask, will I have to still do the 9 months to 1 year of practice, or yeah, that's what I mean.
That is equally a good question. So, in that respect, Nigeria is discriminated because you must be a citizen of Nigeria. You understand? Before you become a lawyer. So, if for one reason you don't have any connection with Nigeria, then you cannot be able to practice. You cannot be able to become a lawyer in Nigeria. So, being a lawyer in Nigeria is tied to citizenship, which is in a way discriminatory, right? But that is how the law is designed. However, if you want to go to Nigeria and practice, you are a lawyer in another country, in Kenya or Australia, you want to go to Nigeria and practice, you cannot do so based on our current law. But recently, the Legal Practitioners Act, which is a law related to practice of law in Nigeria, is to be amended, in which there is a provision now which allows foreigners that wants to go into Nigeria and practice to do so. So it's possible that maybe your friend from Nigeria here might have gotten a case and you are an expert, he wants you to come to Nigeria and assist him with that case. Under foreign law, you cannot do so. But with the changes that is coming up, you can go and do so, and they will give you like a fiat, a license, temporarily, maybe depending on how many days or months you want to stay or year. When you practice, you finish, you go back to your country. So that is how it works. Thank you.
Okay, thank you. So we go to the next question.
Good afternoon, sir. Ichi Asiru. My question is not about Nigerian law, likewise it's about international. As you stated before, like here we are studying international law. So as based on my understanding, as someone who studies international law means someone with the global knowledge of legal system international. So if for example in Nigeria someone as a foreigner cannot come into the country and then practice law legal system, what of other places like other countries, and what's the standard of international law on that? I mean, like as an international lawyer, does that mean you can go to other places and practice law? Because in TikTok, I used to saw Nigerians in Australia. They went to the Australian law schools and they also they are Nigerians. So does that mean they can also practice law everywhere? Even before you, that you said you did a PhD in another place, so that means you are an international lawyer. So can you also go to another place and represent something?
Yes, so, okay, thank you very much. That is really a good question. So, based on my knowledge, every country has its own rules related to practice of law. In most cases, it is restricted. So, for instance, I did my master's in UK. I did my PhD in UK, but I cannot practice before English course. Based on their own legal system, before I do so, I have to qualify. And for me to qualify, I have to undertake an examination. It doesn't mean I have to go back to university and study LLB, no. So, they might say because I come from a common law jurisdiction, I might sit for 6 months, exam, I'll be able to read, then go and write exam. That is what they call solicitors qualifying examination. You understand? So I don't know the the practice in Australia, but in most countries, you can't just go and just start practicing as a lawyer. You have to abide by the rules of that country. Why? Because under international law, states are sovereign entities. States have power to decide for themselves, to decide rules related to their own country. So that is a matter for what? For a country within an issue within a country. So international law will not come in to regulate how lawyers will practice in your country. No. But you see, based on my own experience again, there are associations like the International Bar Association. If you qualify as a lawyer, you can be a member of the International Bar Association. It gives you a lot of advantages. What are the advantages? If, for instance, there are cases to be decided by international courts, so it means that you don't have to go and get another qualification. For instance, now I'm a member of IBA, International Bar Association. So if there is a case before the International Court of Justice that involves any of the countries, they can employ me based on my expertise to go and represent them. I don't have to get another qualification because already I'm qualified as a member of a country that is a member of the United Nations. If I want to practice, for instance, before the International Tribunal for Law of the Sea, is an international tribunal, I don't have to get any other qualification because already I'm a qualified lawyer from one of the nation states. Hope you understand. If I want to go before ICC to represent someone, I can do so because I'm already a qualified member of the country that is signatory to ICC. So when it comes to international courts, international institutions, insofar you qualify legally in your country, you can go and appear as a lawyer. But you can't go into another country and say because you qualified in your country, now you want to practice as a lawyer. It doesn't work that way. I can't just go into Australia and say, I'm a qualified lawyer from Nigeria, I will represent someone. No, it will not work that way. Thank you.
Okay, thank you for the question, Ichi. Okay, for the first, maybe we want maybe 2 or 3 questions from the group. If there is no one raise their hand, it means we will point, yeah, for 2 or 3 of you.
If you don't ask me, I'll ask you a question.
Yes, exactly. So before we point, maybe someone will raise your hand and ask questions related to our materials today. Okay. For the girls, we still have 0 questions. Or we will point, already, we will point maybe the questions to the girls because no girls question. Yeah. About this. Silakan Aldi.
So just because our time should be finished in 12, I already coordinated with Miss Aroma. So is there any questions so far? No? Then maybe we'll have class with Miss Aroma. Okay, so if there is, do you have any other exploration again about the Nigerian legal system? It's already finished everything. Okay, so then let's we close our meeting today with Abdallah. Alhamdulillah, Rabbil Alamin. But before that, I think we need to have a photo session with all of you. Disability souvenir, and then I will give you the souvenir, and as an exchange of kind of appreciation. Yeah. Let's have a picture first. Then we will have double. Okay, Paul, maybe after this you can collect the summary. Okay? Thank you.
Why? Oh, today you don't have any class. Oh, okay. So tomorrow is Miss one class, not today. Oh, okay. Stand up, please.
Ready, 1, 2, 3. Okay, thank you. And this will be our exchange.
This